Across the UK, short-term lets, including those listed on Airbnb, Booking.com, VRBO, and similar platforms, are facing the most significant proposed and emerging regulatory changes in their history. New planning rules, a planned national registration requirement, and strengthened local authority powers are reshaping how the sector is expected to work. Whether you're a host, a landlord, a traveler, or someone simply trying to rent a home, these changes matter. Today, we're breaking down what the government has already changed, what is legally in force as of January 2026, and what is still at the proposal or parliamentary stage. Section 1, How we got here, the rise of short-term lets. Let's start with the background. Over the last decade, short-term letting has grown from a niche sideline into a major part of the UK's visitor economy. In cities like London, Edinburgh, Manchester, Bristol, and in coastal areas such as Cornwall, Devon, and Brighton, thousands of properties shifted from long-term residential use to year-round holiday accommodation. What began as homeowners renting spare rooms expanded into entire properties being operated commercially. This growth brought benefits, extra income for hosts, more accommodation options for visitors, and increased tourism spending. But it also created well-documented challenges. The major issues. Housing shortages. In high-demand areas, long-term rental supply fell as homes moved into the holiday let market. Community disruption. Frequent guest turnover changed the character of some neighborhoods. Noise and nuisance complaints. Councils reported increased issues linked to party lets and unmanaged properties. Safety and standards concerns. Short lets have not always operated under consistent inspection regimes. Regulatory blind spots. Councils lacked reliable data on how many short lets existed or where they were located. These pressures, especially the impact on housing availability, are the main reasons the UK and devolved governments have intervened. Section 2, the government's new framework, 2024 to 2026. In 2024, the UK government announced a major policy shift, new planning rules for short-term lets in England and a mandatory national register. By 2026, the direction of travel is clear, but some of the detailed rules are still being implemented or finalized. These changes are designed to give councils better oversight, protect housing stock, and ensure short-term accommodation meets basic safety expectations. The key measures and proposals include 1. Planning permission for future short-term lets, England. The government has confirmed its intention that, in England, operating a property as a short-term let, unless it is your main home, will generally require planning permission under a new, short-term let use class. This is designed to distinguish holiday accommodation from standard residential homes. The detailed rules and commencement dates depend on secondary legislation and local implementation. 2. A mandatory national register, England. A mandatory national registration scheme for short-term lets in England has been announced and enabling powers have been taken, but the full system and enforcement timetable are still being developed. The policy aim is that platforms will only be able to advertise properties with a valid registration number once the scheme is fully in force, but this is not yet operational as of January 2026. 3. Council control over local rules. The government's proposals would allow local authorities to designate, control areas, and use planning tools to manage concentrations of short-term lets, particularly in areas with severe housing pressure. How far and how quickly councils use these powers will depend on local decisions and the final form of the legislation. 4. Main homes exempt up to 90 nights. Policy statements indicate that homeowners will be able to let their primary residence for up to 90 nights per year without needing planning permission, mirroring existing approaches in places like London. This exemption is intended to apply only to genuine main residences and will be defined in the final regulations. These are not just ideas on a whiteboard, but for England, many of the planning and registration details are still moving from announcement to full implementation. Section 3. Why these rules are being introduced. So why tighten the rules now, after years of rapid growth? Reason number 1, housing availability pressures. In many tourist hotspots, local renters struggle to find affordable homes. Councils and housing organizations have repeatedly warned that the expansion of short lets has reduced long-term rental supply. Reason number 2, community concerns. Residents in high turnover areas have raised issues about noise, antisocial behavior, and the loss of stable neighborhoods. Reason number 3, safety and compliance. Short lets do not always meet the same fire, gas, and electrical safety standards required of hotels and guesthouses. The proposed National Register is intended to support minimum safety compliance by giving authorities better information. Reason number 4, local authority oversight. Councils have long argued that they cannot manage what they cannot measure. The register is designed to give them the data needed to enforce rules more effectively. These reasons, especially housing pressure, are the driving force behind the reforms. Section 4, What's in force in 2026? By January 2026, some important changes are already in place, while others are still in the legislative or rollout phase. 1. National Register for Short-Term Lets, England. The National Registration Scheme has been confirmed as government policy and enabling legislation has been passed, but the full, mandatory system is still being designed and phased in. Hosts should expect to have to provide details such as property address, ownership details, safety certification, fire, gas, electrical, maximum occupancy, insurance confirmation. However, as of January 2026, the requirement for a registration number before a property can be listed on major platforms is not yet fully in force across England. 2. New planning use class for short-term lets, England. The government has announced a dedicated planning use class to distinguish short-term lets from standard residential homes, with associated permitted development rights. The detailed implementation and local application are still being worked through, and the position can vary by area as secondary legislation and local plans are updated. 3. Planning permission requirement. The policy direction is that any property that is not a main home and is used as a short-term let will generally require planning permission in England. Some of this may already be reflected in local planning decisions and emerging national rules, but it is not yet a fully uniform, long-established requirement everywhere. Existing short lets may benefit from transitional or grandfathering arrangements, depending on the final regulations and local authority policies. 4. Local Licensing and Planning Bills, 2024-26 session. The UK Parliament is considering additional legislation related to short-term lets in the 2024-26 session, including private members' bills such as the Short-Term Lets, Planning Permission, Bill, which would require planning permission to change a residential home to a short-term let in England. These bills are at an early stage and are not yet law, none of their provisions are in force as of January 2026. Separately, the Short-Term Let Accommodation Bill, introduced in the same session, proposes stronger local licensing powers and national standards for marketing, safety, and enforcement. It is also at an early stage, and no provisions from it are currently in force. Councils may be preparing for potential future regulation in light of these proposals and wider government policy, but there is no single, mandatory national licensing framework in operation yet. 5. Abolition of the Furnished Holiday Lettings, FHL, regime. From April 2025, the FHL tax regime was abolished. Holiday let operators no longer receive capital allowances, business rates, style relief specific to FHLs, FHL-specific tax advantages. Income and gains from furnished holiday lets are now treated in line with other property income and gains. This change is in force and affects owners from the 2025-26 tax year onwards. These developments reflect confirmed tax changes and a strong policy direction on planning and registration, but not all of the planning and licensing measures are fully operational yet. Section 5, How councils are responding. Local authorities are starting to use, or prepare to use, the new and proposed powers. London. London boroughs continue to enforce the 90-day rule for short-term lets in many cases and are monitoring national proposals on registration and planning use classes so they can integrate them into local planning and enforcement systems once fully in place. Edinburgh and Scotland. Scotland already operates a licensing system for most short-term lets, with control areas in place in some locations, such as Edinburgh. These regimes are fully in force and have influenced debates and policy development in England. Cornwall and Devon. Councils in high-pressure coastal areas, including Cornwall and Devon, are exploring or consulting on tighter planning controls, control zones, and stricter rules to protect housing stock, in anticipation of and alongside national reforms. Manchester. Manchester is reviewing planning and housing policies to manage neighborhoods with high concentrations of short-term lets, using existing planning tools and preparing for future national changes. With the combination of existing powers and forthcoming national rules, councils are gradually gaining more tools to manage short-term lets more consistently. Section 6. What this means for hosts in 2026. If you're a host, this is where the changes become real. Impact number 1. Planning permission expectations. In England, you should assume that operating a short-term let that isn't your main home may require planning permission, either now or in the near future, depending on where you are and how quickly the new use class and related rules are implemented. Hosts will increasingly need to show compliance with local housing policies, no unacceptable impact on neighbors, adequate safety measures. Impact number 2, registration obligations. A national register for short-term lets in England is planned and moving towards implementation. Hosts should expect to have to register their properties and provide key information once the scheme goes live, and that platforms will eventually be required to check registration numbers before listing. The exact start dates and processes are still being finalized. Impact number 3, higher compliance costs. Safety checks, insurance, and any future licensing or registration fees are likely to increase operating costs. Hosts should plan for fire risk assessments, smoke and CO alarms, electrical safety reports, gas safety certificates, where applicable. Impact number 4, reduced flexibility in some areas. In high-pressure housing markets, councils may use planning and, where available, licensing powers to restrict new short-term lets or refuse permission entirely. Impact number 5. More consistent enforcement. As planning rules tighten and a register is introduced, councils will find it easier to identify and act against non-compliant properties, leading to more consistent enforcement. Impact number 6, market consolidation. As compliance becomes more demanding and tax advantages such as the FHL regime fall away, some hosts may exit the market, leaving more space for those willing to operate on a more professional, fully compliant basis. These changes don't eliminate short-term letting, but they do formalize it and remove some of the previous tax and regulatory advantages. Section 7. What this means for travelers. For travelers, the impact is mixed. Pros. Safer accommodation, greater emphasis on safety standards and clearer responsibilities. More reliable listings, a registration system should reduce the risk of fraudulent or unsafe properties once fully implemented. Better neighborhood balance. Stronger planning controls may reduce disruption in residential areas. Cons. Fewer listings in high-demand areas, especially where councils restrict new short-term lets. Potentially higher prices, reduced supply and higher compliance costs may feed into prices. More competition during peak seasons, particularly in coastal and tourist hotspots. Short-term lets won't disappear, but the experience is likely to become more regulated and more consistent over time. Section 8. The future of short-term lets in the UK. So what does the future look like? Scenario 1. A more professionalized sector. Hosts operate with clearer rules, planning requirements, and safety standards, and fewer purely informal arrangements. Scenario 2. Stronger local control. Councils have more tools, through planning, licensing, and registration data, to manage short-term lets based on local housing needs and community impacts. Scenario 3, a stabilized market. With better oversight and the removal of some tax advantages, the sector may become more sustainable and predictable, even if growth slows. The era of largely unregulated short-term letting is ending. What's emerging is a more structured, transparent, and accountable system, though some of the biggest changes are still in the pipeline rather than fully in force. So, is this the end of Airbnb as we know it? Or the beginning of a more balanced approach that protects both tourism and local communities? Let me know in the comments, are these new rules fair? Or are they going too far? Hit like if you learned something new, subscribe for more breakdowns of UK housing and legal changes, and I'll see you in the next one.